Earlier in the day, we had the felony DUI because of the child abuse charges. Today, we had a motion to suppress this afternoon, and we filed a motion to suppress saying that the police did not have probable cause or reasonable suspicion. Throwing out the breath test, there were problems with the breath test too. And it just so happened that it was Deputy Register's case, who has facing criminal charges of his own, trafficking in methamphetamine. So this case is never going to go anywhere. And so we filed a motion to suppress, no probable cause for the arrest. It was granted. So a motion to suppress, what that is where the police violate your constitutional rights or did not have the facts necessary to give them probable cause to arrest you or search you. So that's what the motion was, and the judge granted our motion. There's no probable cause for the arrest. If there's no probable cause for the arrest, you cannot get to a higher standard and prove this charge beyond a reasonable doubt. Breath test evidence is thrown out. Field sobriety evidence is thrown out. All the statements are thrown out. So this case is going nowhere. So I expect it to be null prost and dropped by the prosecutor. But that's why you need an experienced attorney who knows the rules, how a breath test machine works, because if Deputy Register was not arrested, this case would have been going forward, and then we had grounds to get the breath test thrown out or to show a jury that the breath test machine was not working properly. But that comes through training and experience. And years ago, we were able to go and get training on the Intoxilyzer 8000 from the former FDLE alcohol testing program director and higher ups to know how this breath test machine actually works and doesn't work. And you have to know where to find the information so that you can show the breath test machine wasn't working properly. So a lot of attorneys just don't have that experience. You know, they're promising you things on, when you're talking to them on the phone. They don't have the education, they don't have the experience, and they have not fought these. And I'm one of the few people in Polk County that regularly, in the state of Florida too, regularly are filing and fighting the breath test. So today ended up being a great day. The charges are not going to go anywhere, and it's going to save my client's career. And that's what we're here for. So if you've been arrested for DUI, you've got 10 days to take action. Call me. And remember, October 1st, the law is changing, so refusing the breath test is now a second-degree misdemeanor. You can get up to 60 days in jail.